my name is Betsy Johnson. I am the policy advisor for the Treatment Advocacy Center. I've been with the organization for almost 5 years now, hard to believe. But prior to joining TAC, I was at NAMI, Ohio for 10 years, where I oversaw their advocacy agenda and worked on getting assisted outpatient treatment language passed in our legislature. I am also a family member. So it is with that perspective that I serve on the AOT implementation team. And I am joined by my colleagues, Amy Lukes and Brian Stetton, who are with me here today. So I'm going to let them briefly introduce themselves. Amy, if you want to go first.
Hi, I'm Amy Lukes. I am calling in from Minnesota. I'm a part of the implementation team. I'm also a clinician who's worked in an AOT program. So,
hey everybody, I'm Brian Stetton. I'm the policy director of the Treatment Advocacy Center and kind of oversee our AOT implementation efforts. And I know many of you, very great to see so many friends on the line today. I'm an attorney. I'm not an AOT monitor, so I'm going to be pretty much a fly on the wall in this conversation today. I think all three of us are really hoping that you guys, the monitors, will kind of drive it. So I'm really interested in learning a lot about your perspectives. And thanks for everyone for being on.
So, so this is actually our second discussion group of the AOT Learning Network. Just wanted to give you a little bit of, thank you, Amy, a little bit of history about the AOT Learning Network. We actually have been piloting this in Ohio now for almost 3 years. And we've got lots of my colleagues from Ohio are on the line with us today. So anxious to hear, from you all in terms of what you've experienced being part of the Ohio version of this. You probably didn't realize you were guinea pigs at the time, but we've been having a lot of success. It started out as sort of an AOT monitors group, and we've expanded our name to the AOT monitors and stakeholders group because we've got now a lot of folks involved in the AOT programming at the local level who participate. And we meet regularly and share information and help each other troubleshoot when we run into problems. It's been a lot of fun and quite a success. So we've built the learning network based off of that experience. And the learning network will include many elements. One are discussion groups like we're having here today. This is actually our second such discussion group. And we have others planned for the future. We've also are hosting webinars. We had one last month. I hope you were able to join us. And then we have another one coming up in July. It's going to be held by our Director of Research, Elizabeth Hank, and she's going to be talking about the importance of data collection in AOT programs and helping to hopefully simplify that. It can be kind of overwhelming, and hopefully she'll make that feel easier for you. Other things we'll be doing is we're sharing resources. Again, we've been doing this in Ohio for some time. We share policy, procedures, forms, handbooks, participant handbooks. We have all sorts of tools that will make their lives easier. Some of these are already available on the Treatment Advocacy Center's website, and we're in the process of updating those and putting some of the high quality examples available for you. So we'll be ready to share that list with you in the coming weeks, we hope. Also, let's see, that pretty much constitutes what you're going to be able to access through the learning network. So we really encourage you to encourage your colleagues who aren't currently on the network to join, because the more people that are on the network, the greater, the more robust that experience will be, and the more opportunity you'll have to learn from each other. We will be also doing some discussion groups. For instance, this discussion group today is really intended just for AOT monitors. I know we have several other people that have joined us, and we certainly appreciate you being here. But really the goal is for people whose responsibility is on a day-to-day basis of monitoring people who are in AOT programs. making sure that the program runs smoothly, and just we really call them sort of the glue that holds the program together. They're really responsible for monitoring people and communicating between the mental health system and the court system. In fact, we often get requests for position descriptions, and one of the more frequent requests we get is for AOT monitor position description, because it looks so different in every jurisdiction. We put together the position description that I sent you attached to your email last week. I'd love for you to take a look at that and see how that compares to your role as an AOT monitor, and maybe look at that list and see what's missing, and get those other responsibilities to us. It may mean that we have 2 or 3 different examples of AOT monitor position descriptions, because they look so different in different jurisdictions. In some programs, you've got the judges playing a key role. In other organizations, judges aren't as active, and then some have sort of a mix, kind of fall in between. So oftentimes the AOT monitor's role varies depending on the level of a role that the judge in your court plays. So please take a look at that and get any suggested changes to us, and at our next meeting we can kind of go through the description and see whether or not it makes sense to have maybe a few different examples. But it's always helpful for new programs to be able to look at those position descriptions so they're not starting from scratch. So we really want to kind of turn this over to you. This is a discussion group. I don't want to talk your ear off, so I wanted to maybe throw out a conversation starter. We get a lot of questions at Treatment Advocacy Center, so I tried to identify a couple that are some of the more common questions that we get, and just want to hear from you how you respond. There's not a right or wrong answer to any of these. They all vary based on your varied programs and how you approach AOT. But it would be interesting to hear different examples of how you handle this. So I apologize for reading to you, but I'm just going to read the description or the scenario, and then open it up and hear from you all. So this first one is, Ray's mother has petitioned the civil court for AOT, but the court has told her that she does not have sufficient evidence to prove that he meets criteria for AOT. He has been hospitalized on several occasions over the past 5 years, but his mom cannot specify where or when because she does not have permission to view his medical records. 2 months ago, he quit taking his medication and is decompensating. He has not seen his doctor in over 6 months and refuses to be evaluated. Last weekend, he threatened the neighbor. The court suggested to Ray's mother that she contact the AOT monitor to find out how to get Ray into the program. How would you advise the mother?
This is Nick Schrantz from Butler County. In a case like, I guess I'm assuming he's not already under an AOT order, Betsy?
Correct, that's correct, Nick.
So because he's non-compliant, the first issue I would do is call the crisis team. If there's a mobile crisis team in the community, to go do an assessment, so the assessment can go to him if he's not going to go to the assessment. And at that point, see if he's in need of inpatient hospitalization. I know in our county, as in many counties, a civil commitment order often starts in the hospital setting and then transfers to an AOT order upon discharge. So because of the non-compliance, I would start with the crisis team if there was one available.
Nick, I'm curious, would you involve your local NAMI affiliate? Would they have any role in this?
I certainly think they could be supportive of his mother, who seems interested in his well-being, but is, as often is the case, feeling left out of the picture because releases of information haven't been signed, so she can't take as active a role in the situation as she would like to. So certainly they can be supportive of her and in the situation that she's going through.
Mac, we'd love to hear from you. Can you unmute?
Yes, good afternoon. At least in Michigan, I believe, petitions and physician certificates are a matter of public record. She might be able to access those and have a pretty good idea when those hospitalizations were and where.
This is Tara Schultz from Licking Knox counties in Ohio. And as the monitor, I actually work at our ADAMH board. And so had any of those hospitalizations actually been a probate court process, had there been a commitment, there would have been a notification made to the board. So we would have those records here at the board. But I know not all of the monitors are actually employed at the board level, but your local ADAMH board in Ohio would be notified of any probates that have been done on their county residents.
So Tara, would you assist the mother in completing the affidavit?
Well, based on the scenario, I was kind of reading into it that perhaps she already had wrote the affidavit, because it said she petitioned the civil court. So I assume that was what initiated that contact with the court in the first place. You know, if I had access to those documents around the probate, I could certainly look and see what was a impact of those, presenting problem of those hospitalizations, because, and I'm not sure on the nuances of the law in other states. I know within Ohio, there's those criteria around 48 months and 36 months. And so I may be able to cull from that information if some of those things do exist, that then might be new and additional information to provide to the court regarding his eligibility. But I am also with Nick in terms of my primary concern right now would be safety, and I would want to make an effort to have him evaluated, and if he's not coming in, we may employ CIT officers to provide that community level assessment. We have a crisis team, so it would just be a matter of what made the most sense to have him assessed now in the moment as well.
Thank you.
Heather Vance.
I'm just going to add a quick point of clarification about this scenario, because it might be confusing to some of you based on your own state laws. This question of how many times a person's been hospitalized in the last couple of years and what the nature and the cause of that hospitalization were is a really big issue in some states and a non-issue in others. And it just depends on what the criteria are for AOT. And I think in this scenario, we're assuming we're in a state where the actual law says you're not eligible for AOT unless you've been hospitalized a certain number of times. Typically, it's 2 hospitalizations in the last 36 months or 48 months. Some states require that there be evidence that those hospitalizations were the result of non-compliance with treatment. But of course, many of your states, there's not this absolute need to prove that to get somebody AOT. So, you know, this is one of those situations that it could be a greater sticking point in some places than others.
Heather Vance, California.
In this scenario, if this was in California as the AOT monitor, once the AOT investigation is open, there is no HIPAA, so we can gather records that we can use to see if he meets the criteria, which if he does have those hospitalizations, then he would. And he is decompensating. So I would do an investigation, gather the information, put together the criteria and a checklist. And then when I would have an opportunity to assess him, if I was able to assess him, then at that point, determine if he needed a crisis evaluation, if he was meeting criteria to be involuntarily hospitalized, or if we could move forward with the AOT petition.
So Heather, you'd be able yourself to just get those records from any hospital that the mother tells you she remembers him being treated in?
You know, it certainly in California, since we're fairly new to AOT, it would take some convincing, I'm sure, but it is in our law that we are allowed to gather the information for purposes of the AOT petition?
Yeah, there is a, you know, HIPAA, certainly some states have their own versions of HIPAA that could impose a lower ceiling, but in terms of the national HIPAA law, there are all kinds of exceptions, as you all I'm sure know, carved out for when sharing does not require the person's express permission. And, you know, there have been arguments as to whether any of those exceptions actually apply to this situation that we're describing now. You know, one exception is that members of a treatment team, people are already a part of an established treatment team working with the patient, then record sharing is considered routine. But that's not necessarily the case at the point at which we are at in this scenario. So, you know, it's open to interpretation.
Yeah, and I know we have that specified in our law, but the other piece would be if it was an emergent situation and the person was actually in crisis, then we would be able to get information as well.
The other nuance that would be of interest to me is around those previous hospitalizations, because if I cannot find from the ADAMH board level, if I don't have record that these were probated admissions, therefore they were voluntary admissions, that also would come into play in terms of exploring AOT. If he was hospitalized on a pink slip, but then signed in voluntarily at the hospital end, which is actually in statute that they're supposed to make every effort for that to happen, then that also has to be considered overall in looking at that outpatient.
Yeah.
Yeah.
Which is why it always bugs me when the laws, some state laws do require that those previous hospitalizations have been involuntary. And, you know, we all know that many people come into a hospital for an involuntary evaluation and then are persuaded to sign themselves in. So that distinction between voluntary and involuntary hospitalizations can be fairly arbitrary, and we don't really think it is a sensible way to, you know, discriminate when writing these laws, requiring those hospitalizations to have been involuntary seems kind of arbitrary to us.
Now, what we have done in our county, and we're not as rural as many counties, but certainly not as urban as others. So when we have a case that we're working with a provider around because they believe they need this outpatient commitment, this assisted outpatient treatment, a lot of times what we will do is, if we know they're going into the hospital on the pink slip, we will contact the hospital and indicate that we do not believe this individual is competent to provide consent for treatment, and that they should not be allowed to sign in voluntarily, because then we can get that commitment at the hospital side. So sometimes it's taken some preemptive efforts on our part to have that be the case.
And it's ridiculous that you should have to make those efforts. It shouldn't.
I agree. I agree.
Yeah, we got to fix that.
Yeah, but that's a great example of the importance of communicating with all the parties communicating together to try and come up with a plan that makes, you know, that makes it's in the best interest of the patient. So that's great that you guys are doing that. Anybody else want to comment on this? Oh, Nicole.
Okay, let's just read her comment then.
We get pushback from hospitals in Bexar County because OPCs cost $500. So the actual
outpatient
hearing, the hearing costs $500. What? That's a direct quote.
There is certainly a cost to the counties. Again, if we have someone on outpatient commitment on assisted outpatient treatment, they are committed to the ADAMH board. So the ADAMH board is party to that court hearing. So we actually have to pay for our own representation. So I know that that's a cost we do incur.
I have a comment, but I'm not sure you can hear me.
We can,
Yes.
Carol. That's Carol
Okay.
Stansfield in Nevada County, California.
Yes, thank you. Just a couple of things. I think our experience in Nevada County is that we don't have hospitalization. You know, if I get a call from a parent or there's a referral, I don't recall ever getting a narrative about somebody who's been hospitalized who went in voluntarily. I think that most people that are referred, even if I can't look at that, you know, the initial phone call or the subsequent paperwork and say, yes, this person meets all the criteria and we should be going forward with this, I would strongly encourage a closer look, so an investigation. And we have the ability to collaborate with the county here and talk to others as well. As Heather said, there's a period of time once we get noticed that somebody may meet criteria that we can, it's similar to our 5150. There's a window of opportunity there where we can go ahead and access information that we need to make the case. And my feeling is that this is all, you know, we're doing this to prevent people from decompensating even further. They have a history that we're hearing from parents, or they have, the county is concerned but not quite sure they meet criteria, then that kind of triggers that question. Let's take a closer look and maybe see if this person, maybe we can prevent something very serious from happening if we get to know a little bit more about, because this scenario doesn't say to me this person meets criteria. This says, you know, potentially we have not just the hospitalizations but the other components of the criteria that needs to be met.
Mm-hmm.
So who do I need to talk to get that information? And that's where I would go from there.
Okay, I'm going to move on to scenario 2. So your county's lone community mental health agency psychiatrist, Dr. Jones, believes that if an AOT participant adheres to treatment for a minimum of 90 days, the person no longer needs to be on AOT and the psychiatrist refuses to request a continuance. How would you address this problem?
The psychiatrist is an important part of the team, and oftentimes they are, you know, fully familiar with the individual who may be doing, you know, better after 90 days. I would say that this would require some collaboration with the team there, and I think that that's, you know, there's this, it's a better team when there is that full collaboration among the providers, the monitor, the judge. When we get everybody's voice in that conversation, then we're really doing the best service we can for the individual. So I would say, you know, certainly our psychiatrist is open to that feedback. She also provides feedback, but it's more of a collaborative decision then, because it isn't just the psychiatrist's information that goes into that petition and into the order. It is, it really is a number of people that we talk to that creates that assessment that leads to ultimately the order for AOT. So I would say I would probably be having a discussion with the psychiatrist to suggest we attempt to extend it a little bit longer, because 60 days isn't enough, 90 days really isn't either. We have to operate out of what our law says, because we don't have the ability to say, well, you know, this person really isn't back to baseline yet. So I think it really it's back on the team to say, you know, how well do we know this person? How much have they compensated? And are they in a place where without this, they're going to be able to sustain the gains? And sometimes that does happen with that more robust treatment engagement, but sometimes it doesn't. And we've seen AOT be very successful, but then once a person is off, they're off, and then all the good stuff that happened goes away. So I would probably be advocating pretty strongly for a continuance.
Right.
Yeah. What's your
Thanks.
sense, Carol, of typically how long is the sweet spot for people to really be able to hang on to the gains they make?
I'd say 18 months, and we've had people enrolled extending to, you know, 6 months and 6 more months, or variables. I mean, the judge is great at motivating people to say, well, why don't we try it another 4 months or so, or 2 months? You know, there's no definite period of time, but it could go additional 6 months. So that's what's within our implementation plan. But I think 18 months, it would be fantastic if our law changed to 12 months even. I mean, that's a good period of time to really help to establish some new ways of self-management.
So in looking at this, I would try to talk to Dr. Jones, and in my opinion, and I think probably the way AOT is designed is to indicate that the important issue is not necessarily the respondent's behavior, but their insight. AOT is a program based, in my opinion, more on insight than behavior. And the question that Dr. Jones needs to be asking the respondent is, does the person have the insight to acknowledge, to some degree, having a mental health issue that requires treatment, and some indication that the person has the insight that the treatment is beneficial and they'll continue it without the court order. So we have people in Butler County who have been under civil commitment for 13 years who have not been re-hospitalized, but the treating psychiatrist in the community believes that they don't have enough genuine insight to continue treatment without the court order. So even if their behavior has been where they are complying with treatment and not in the hospital, the psychiatrist believes that without the court order, they would stop that treatment and of course then decompensate and end up back in the hospital. So the main goal, in my opinion, is insight rather than the actual behavior. The behavior lends credence to whether or not they have insight, but it's more than just behavior I would look at.
If some people are persuaded by numbers, if we could make a case that people who are on AOT for only a short time have a significantly lower rate of following up with treatment, maybe have a higher rate of rehospitalization as compared to people who are on AOT for, let's say, a year or more, that could be persuasive.
Yeah, that's a great point. And in fact, we do have that data. That's one of the few variables within AOT programs that we really do have some very solid research to inform. And we have studies in North Carolina and New York that both suggest that more than 6 months on AOT leads to a greater likelihood of the gains being sustained. And in fact, in the North Carolina study, they actually found that people, even while under AOT, did not do as well in the first 6 months as they tended to do as they continued on and longer in the program. So we're happy to share that with you if you're ever in that situation, or even if not, we have those studies. Email us.
I would also have to wonder how long the psychiatrist will hold on to this position. not his position as a psychiatrist, but his
Oh.
position as 90 days is good enough.
Yeah, well,
Hopefully not long.
some people are more persuadable than others, as we all know.
Mari?
Hello, this is Mari Tez. I'm from Doña Ana County. I definitely agree that it is very much a team decision and a team conversation. And we have some really great conversations between the whole entire treatment team with our judge. And our judge is extremely supportive of listening to everyone's opinion. And then also, if she has to, she can make a ruling on it. But we have come together as a team because right now our orders are for a full year, but we do have clients and we do have practitioners who would like to take them off of the AOT order within 3 months because they can't get a hold of them. And we have found that when we do that, they often come back into our system. And so we have decided as a team over the past 3 years that we are going to try and engage the client on a monthly basis for the entire year. And we try and encourage them to receive treatment and encourage them to come to court and encourage the case manager to go visit them once or twice a month. And that has really helped us a lot. I also saw another comment about replacing the psychiatrist with nurse practitioners, and we actually use psychiatric nurse practitioners in our program, and we have had amazing luck with them, and we have had such great buy-in into the program and such amazing collaboration with them that they are willing to go to court hearings, that they are willing to, you know, if they're not able to be there in person, they can call in and listen to the entire team, including peer support specialists and the judge and, you know, just everybody that's on the team. So we've had really, really great experiences with psychiatric nurse practitioners.
That's awesome.
And I want to say that in my experience, in my experience, the nurse practitioners I worked with were hands down better than most of the psychiatrists we had available to us. They were more compassionate. They were just as knowledgeable, and they were much better at engaging people than the doctors were. I think that's part of the nurse mindset that's not necessarily something that they teach in medical school. I mean, they try to teach it, but more often it's, emphasis on knowledge and not on soft skills. So.
And I'll also chime in with just acknowledging that the alternative that Mari is suggesting is not going to be available in a lot of states because there are many states that require the testimony of a physician to order or renew AOT. So it really is going to be up to the doctor.
And I know here in Ohio, I mean, I was a little jealous that they had a psychiatrist because we have so many APNs and CMPs, which are fantastic and provide wonderful service. And so when we've had an individual who we need that continued commitment assessment, it does have to be a psychiatrist. So what happens for us in my county is that has to go to the medical director of the organization. It's not even the treating physician or the treating prescriber because of that, because it has to be that doctor, which in some ways actually provides some objectivity. Sometimes when you're close to the case, you can kind of lose perspective from time to time. And yeah. The other thing I'm always cognizant of with this order is it's very invasive. And so I try to really very diligently look at the law. What does the law say? Does this person actually meet criteria? And I can know in my gut that I don't think it's going to continue. Most typically, it's not an issue to get beyond the 90-day commitment, because if we've already met that criteria of the last 36 months, the last 48 months, that's going to persist beyond the 90 days. So more often than not, that's a non-issue. But by the time you get to that 2-year, and we've had a situation recently where we had an individual who had been on the commitment status for a total of 4 years. And when it came time for the continued commitment, we had that objective medical director who wasn't the treating prescriber, and she challenged me, and inappropriately so. When was the last time there was an act of violence? When was the last time that he needed to be hospitalized or was refusing treatment? And we didn't have that. So we ended up having to terminate that status, and within a month, he ended up back in a hospital. Now, it wasn't obviously we were trying to avoid that, and yet there's something to be said for the rapport that built with that client. We did end up putting that client back on outpatient commitment, but from the treatment team standpoint, they could say to him, we allowed you this opportunity, you had this opportunity, and you didn't continue with the treatment, so that's why you're back on it. So, I mean, I'm always just very aware that as much as I want this to solely be a clinical decision, it really has to be based in the law of it too.
Right. Good point. Well, Amy, Brian, and I were talking earlier today about some other topics for discussion groups, and one of them we talked about was knowing when somebody is ready to graduate from AOT. I think that would be an interesting conversation.
Maybe even a webinar that we'll do for the entire learning network.
Yeah.
And just so you know, that New York, actually, they only have independent evaluators in their AOT program. They get records from the prescriber, but it is not the treating physician or nurse that provides the evidence for AOT. So that's not unusual.
Yeah, New Jersey works that way too. I don't know if we have anyone from New Jersey on the call today, but they also have, typically on the AOT team, they'll have an AOT psychiatrist whose sole role is to do those evaluations, not be involved in the person's treatment day to day.
Next on our agenda, we really just wanted to open this up. So if you're having, running into a barrier in your program, this is the opportunity to bring that up and see if maybe somebody else might have a solution. I know we do this when the AOT monitors in Ohio get together in person. This is always our lunch discussion, and we always run out of time. So this is a good opportunity just to, ask your peers how to overcome some issue you might be having.
Matt Coleman from Oakland County, Michigan.
Go ahead, Matt.
We have an interesting arrangement in Michigan now where to apply for AOT, or Kevin's Law as we call it in Michigan, you need a petition co-signed by a psychiatrist, not a nurse practitioner, but a psychiatrist. Or you need a physician certificate completed by a psychiatrist, and this must be based on a recent evaluation by the person. There's been no formal definition of recent, but kind of reading between the lines, talking to people at court, I garner that it's something within a month. Now, obviously the question becomes, how do you get that with the person who actively resists treatment?
Mac, do you guys do most of your AOT commitments with people who are coming directly from the hospital from an inpatient stay?
Yes, we are. I would say
Yeah.
at least 3/4 of them are getting an AOT order as part of an order for hospitalization.
Right. So obviously the issue you're raising is not an issue with those folks because they're there right there in the hospital to be evaluated. But it's a question about that other quarter, the folks coming from the community who you're hoping to step up to a more restrictive level of care.
And this is Nick Schrantz again, and I would agree completely with Mac's statement that the issue that we deal with in Ohio with a strictly outpatient civil commitment, so not somebody coming out of the hospital, is the same issue. If someone is non-compliant, they generally have not been accessing their treatment in the month or two prior to a family member or a treatment team member filing an affidavit. And so yes, getting that expert testimony, whether it's written testimony or live court testimony, is very difficult and is proving to be the greatest hindrance to utilizing the outpatient order, the pure outpatient order.
I just think it speaks to the fact that AOT from the community is a really hard thing to pull off. I don't know if that's consistent with everybody's experience, but you know, because you need someone who there's no reason to think meets hospital criteria, right? So you can't bring them in for an evaluation to see whether they want to be hospitalized. But this is someone who is in kind of an oppositional mindset, and you know, you're not going to get them to submit to an exam to be placed under a court order that they want no part of. So I think it's a pretty unusual case where that can really work. I think most kind of step up AOT happens with at least a short-term hold involved, where we bring someone in for an evaluation because we think they might possibly meet inpatient criteria. And then we find that, you know, the doctor just can't quite go there and say that they do, and they have a right to be released back into the community, but they do meet AOT criteria. So now we do have a fresh evaluation that allows us to make that happen. But I think without that situation where there is some reason to think they might meet inpatient criteria, giving us grounds to have a pickup order, I think it's pretty hard to pull off an AOT in the community. I'm curious.
Yeah, our law actually does allow for a pickup order, and they're supposed to be taken to our designated crisis center. What we're finding happens, though, is the police will call an ambulance to transport the person, and the ambulance says, our policy is we take them to the nearest emergency room. Well, and there are a lot of emergency rooms around this area. Yeah. So that's where it usually breaks down.
Yeah. Clearly there needs to be some kind of coordination maybe with law enforcement, with your law enforcement partners.
Mm-hmm. Well,
understand that's not going to work in these cases. So that's probably where I would focus my efforts to, you know, go up the chain of command in the police department to find someone who can make a decision that this is not what we ought to do in these situations where this is an evaluation specifically for Kevin's law purposes. Take them to the crisis center. That's how the process is supposed to work.
Mm-hmm. Oh, the order says take this person to this place, and it doesn't happen.
And they just defy it. Wow.
In a similar kind of vein, that those law enforcement partnerships are hugely important. We had an individual who was on an outpatient commitment and actually left the state. And so we worked with our attorney. We filed the motion with the court for an order of detention that the least restrictive environment was no longer the community and the individual needed to be returned to the hospital, but he was out of state. And we didn't know when he was coming back, and we didn't know where we would find him, and he was hiding from us because he didn't want to see us. So we actually had to contacted a lot of departments, any department that we thought he may have contact with within our county, and provided the copy of the order of detention. And it as it happened, one of the departments had contact with him subsequent to a traffic stop. So it was noted at the dispatch center that there was some reason to call me, which they did, so then we could enact the order of detention and get the individual secured, because otherwise they would have had a traffic contact, maybe given him a ticket and let him go. So those law enforcement partnerships can be very important.
I was just wondering if they do evaluations in the jail, or do they send them to the crisis unit to be evaluated?
I think that varies by jurisdictional policy, Daleen. Ideally, there should be no reason why, if a person's getting psychiatric services in the jail, why they can't be evaluated there. Nick, do you have any experience with that?
We have not utilized a civil commitment order for somebody coming out of the jail setting, mainly because the psychiatric services available in the jail are limited, and certainly I'm guessing that the psychiatrist hours are not going to be spent testifying in a court when they're so needed to see all the multiple individuals in the jail setting who need assessment and treatment at the jail. So sadly, there's treatment in the jail, but the court order waits until they're released from jail in some capacity.
Okay.
Yeah, that's a great topic though for maybe our next meeting. Just to be curious to know if any of you all are using AOT for individuals, nonviolent misdemeanors who are put in jail, even though and need to be restored to competency. But we know kind of going in that the likelihood of them being restored is very unlikely. Are there any folks that are using AOT as an alternative in those circumstances? That's something Treatment Advocacy Center is very interested in monitoring if you're using it for that purpose. I see we're
just a minute.
Go ahead, Amy.
Frank, you want to unmute yourself and share?
Yes, I'm actually I'm a supervisor for Cameron County and Hidalgo County, and we've done that in Hidalgo County where we've had some individuals that were being sent for restored for competency. However, they were not restored, and they cycled through the state hospital as well as the jail for almost 5 years. We were able to get the charges dropped with the condition that the client would commit to a year-long commitment AOT program. And the client's doing well, reunited with his family, on medication, making wonderful progress.
Nice.
That's great. You know, we're always looking for success stories. We've got a new communications director, and we like to do what we call personally speaking blogs or stories, you know, about some successes. That sounds like that might be really a good story to highlight.
Yeah.
And that goes for all of you. Yeah, if you've got success stories you're willing to share with us, we'd love to be able to.
I will say that it took a lot of work between the district attorney's office and the courts, and there in Hidalgo County, they're big advocates for getting individuals help with mental health, and they worked out for this gentleman. It all worked together seamlessly.
Yeah. So Frank's program is down in the Rio Grande Valley of Texas, and at least at the last time I visited there, Frank, the focus was really on the criminal justice system. It was really a lot more like a mental health court than a typical civil AOT program. Is that still the case?
Yes, we're a hybrid, but I would say, Brian, in Hidalgo County, like you know, they're very interested in helping individuals, and if they can't assist a person through the mental health court, definitely we always have the option to use the AOT court. And so we've had individuals that we were able to get the charges dropped, and they just commit to an order. Which is,
yeah. And are you guys serving people that have no current criminal justice charges pending? They're just coming purely out of the hospital system? Or?
Mainly from the hospital. Individuals, we usually get them from, they're converted from inpatient to outpatient.
Oh, okay.
And to hear that you guys have individuals that are on a year-long commitment is wonderful, because usually where I'm at, a client will go in for, say, inpatient commitment for 45 days. Then the state hospital will turn around and push him out as an outpatient, and will only leave 15 days for me to do my magic, so it doesn't work out.
But then you can seek a renewal after that. No?
Yeah, it all depends on the county. I know that in one county it's a little more difficult, whereas opposed to the other county, the ADA and the judge are all on board, and so we're very fortunate to extend some of these orders or reapply for a new order, and
Yeah,
it works out.
yeah. We should talk offline. I'm interested to hear about that difference.
As I mentioned, we're always trying to keep, keep a handle on these so we can start sharing them more publicly, so as you run across stories that are exceptional, if you can keep them in mind. Another thing we're always would love to hear from people who have actually graduated from the program, who may be in a position to communicate what that experience was like for them, what their situation was like before AOT, what it was like while they were on it, and then how life has improved for them after. So we ask that you kind of keep those things in mind too as you're working with folks. But
and
anyway,
in those situations, let me just add, in those situations, we'll only ask that person to go public to the extent that they're comfortable doing so. We would never push somebody beyond their comfort level. There might be people who'd be willing to write something purely anonymously for our website about what AOT has meant to them, and that's great. Someone who wants to be more of a public face is also wonderful.
So Mac has a comment regarding the length of the court order. Apparently Michigan's legislature changed their law last year and went from a full year to 90 days. Did you get that right, Mac?
That's right. We thought initially that must be a mistake because it had been that on a second order you could get up to 90 days inpatient treatment with the remainder of a year AOT, and we thought, well, something must have just been left off. They're going to fix that, right? And we're still hoping that that's the case.
Mac, I'm going to take a close look at the law. That's news to me that they had done that. It's certainly possible that escaped our notice, but that's not usually the direction we want to see these laws move in. So let me check.
I believe.
And get back to
Thank you. I believe that took effect March 29th, 2019.
And so you guys have been living with these shorter court orders since then? You haven't been
Yes.
12-month orders? Wow.
So every 90 days you have to go back to court.
Well, you can get an order after the second order. That would be a continuing order. That's still good for up to a year.
Okay.
But you start, that sounds like Texas, where you start out with a shorter order and then graduate to
We start out with 180 days,
yeah,
go down to 90, and then up to a year.
That's the weird part.
Yeah.
A middle one that's shorter than the initial and then go to a year, that seems like a mistake.
Yeah, it is what it is.
Yeah, but hard to imagine a rationale behind that.
Mm-hmm. They should just check with me on these things.
Yeah, I feel that way too.
Okay, well,
Thank you for bringing that to our attention. I'll definitely look into that.
Last chance for anybody who have a success story they want to share.
I have one. This is Janet.
New Orleans.
Janet.
Friend Janet.
Yeah, so we have two people who are who are graduating out of our program this month, and they've both been incredibly successful. They're young adult males. One of them had 10 involuntary commitments before joining the program and has not had one since then. Both are now employed. One works with a film company and the other has started his own business, and the families are overjoyed with how well they're doing and the, just the reduction in conflicts and escalations at home. Feel really comfortable about going on vacations and leaving them at home, alone and all of that. But neither of them really have gained insight. But they are very compliant with the medications, which is really that seems to be obviously the biggest factor, and they both are interested in helping us with a PSA that we want to do, but they don't want to be identified visually, and so they are willing, but they did ask if we could do something like what the news does and blur out their faces and disguise their voices, and they said they would be more than happy to participate with us as long as we can make them anonymous.
That's great. Great. Thanks for sharing, Janet. We might be in touch with you to see if we can learn more about those cases. So now I want to kind of open this up for you. Sort of had your first chance to see what these discussion groups are going to be like. This is really your meeting. We're just here to facilitate it. This is, if there are things you found helpful or not so helpful, I mean, we just like some feedback. If this is something you think is worthwhile, if so, how often do you think we ought to pull this group together? What are some ways, we can generate some topics? Also want to know if you think there's, some value to having a listserv where you can actually, chat amongst yourselves. If you have a question or you want to bounce something off somebody, we would probably screen it, but then we could bounce it off the group and get some feedback for you in between discussion groups if that's something you think would be worthwhile. We'd really love to hear from you what you'd like going forward.
And it doesn't have to be stated now either. You can email us if you want to collect your thoughts and put that together, whatever you're comfortable with.
I'm from Oakland County, Michigan, so Mac and I have worked together for a number of years. We would definitely have some interest in perhaps a judge-to-judge conversation. I think Mac would agree that typically what we see in our community is that this is less of a program and really just a legal process. We'd like to see that change over time and be much more of that, because what you're describing is much more of a team approach, a great deal more communication than we typically see on a case-by-case basis. So anything that might help us move our partners at probate to kind of a new mindset would be great.
We actually have plans to do that very thing. Our next discussion group will be on July 30th, and it will be we'll be inviting all the judges that we're familiar with that are involved in this program, and we would encourage you to encourage your judge to participate. So when you see that announcement, we'd really love it if you would send it on to your judge with a little note encouraging them to participate.
Great, thank you.
Yeah. And get them to join the network too, because we don't have enough.
Well, terrific. Thank you all so much for spending the afternoon with us and for sharing your wisdom with each other. We really appreciate it and look forward to continuing these discussions.
Sure. Thanks, everybody.
Oh, I see somebody suggesting we get together annually. I do want to let you know it is our hope at some point to schedule a national AOT symposium. We had one tentatively scheduled for April of 2020 and now, or 2021, and now it looks like that's been canceled. But hopefully, perhaps the following year, we will have a national symposium. So be on the lookout for more information about that as soon as things change with the virus. Great.
Awesome.
Alrighty.
Thanks for
Thanks,
joining.
everybody.
Thank you.
See you soon.
Thanks, everyone.
Thank you.